you've been following my blog or staying on top of the news, the latest news story coming out of Florida personal injury law is HB 587. This is a bill that's been proposed and actually passed in the subcommittee in the Senate this past week, which basically stands for the following proposition. If you're a physician taking a letter of protection, you will now have to subscribe to an actual billing system that is arcane and onerous and is meant to make it as cost prohibitive for doctors to treat personal injury clients in this state. Basically, you're going to have to accept a usual and customary charge if you're a physician taking an LOP. Now, what is a letter of protection? A letter of protection is basically a guarantee by either the law firm or by the underlying client that when the case resolves, the physician will get paid back their balance or a portion of such. When a law firm signs off on a letter of protection, we're basically guaranteeing the medical provider that we will earmark from our settlement money in our trust account their outstanding balance, and at that point we will attempt to negotiate that balance down. Now the question becomes, why would you as a physician treat any patient under a letter of protection if you have to subscribe to a usual and customary billing standard? If you have to subscribe to a workman's comp fee schedule or a Medicare Part B fee schedule? How does this make sense? It doesn't. The goal is to take good physicians and push them out of the practice of medicine, or at least out of the practice of handling personal injury victims. Now keep this in mind. Many of these personal injury victims, and approximately 60% of our state, lacks health insurance. What is Rick Scott's answer to this question? What do we do with the individuals who lack health insurance? Who will treat them? What good physician, what good orthopedic surgeon or neurosurgeon will see a patient under a letter of protection if there is no guarantee they're ever going to get paid? Remember, with a letter of protection, the physician only gets paid if the case resolves. If we're unable to get the case settled, if the lawsuit goes south, if the defense is able to get a verdict against the plaintiff, and there's a $0 verdict, no one recovers. That's the risk that the actual physician is taking. That is the very reason, that's the inherent reason, why they're able to charge what they charge. They're able to set their own fee to offset the risk. It's not like billing health insurance. You're not getting paid in 90 days. You're getting paid when the case resolves. Many law firms take forever to get a case done. And it's not only their fault, it's not always their fault. Many times the court system is so backlogged with foreclosure defense cases and bankruptcy cases that it takes a year and a half, 2 years to get a case at trial here in Pinellas County. So how is this fair? This is just another step by the Republican legislature to limit access for personal injury victims to good physicians, to limit their access to the courts, to undermine their cases, to restrict the rights of consumers. It's time to stand up. We went through this last spring, last legislative session. We saw what happened to PIP. Many of my colleagues have no idea about HB 587. It's alarming how few consumers know about this. Learn about it. Tell your colleagues. Call your representative in Tallahassee. Because within a month, we're going to be looking at a system where good physicians will not take letters of protection. All that will be left is individuals who just got out of medical school, or physicians with very shoddy reputations who are willing to stake out the business and take the risk that they might not get paid for their services. Thank you.